This will be the part 6 from the series on 150 keywords on polity. Now, affirmative action is a policy which is aimed at increasing opportunities for the vulnerable sections of the society. They are mainly focused on providing employment, education opportunities, for example, reservations for SCs, STs, and OBCs in government jobs, government educational institutions in India. Now, vertical reservation is a reservation that applies separately for each of the groups specified under the law. Example, reservation for SC, STs, and OBCs, in referred to as vertical reservation. Now, EWS reservation is also classified in this category. Horizontal reservation refers to equal opportunities provided to other categories of beneficiaries, cutting through the vertical categories. Example, women, veterans, transgender community, individuals with disabilities, etc. Now, judicial review. It is a process and a power under which executive and the legislative decisions or actions are reviewed by the judiciary to check the lawfulness of the decision or action. If the actions and decisions violate the constitutional provisions, then the action or decision is declared unconstitutional and void. It was declared as a basic structure of the constitution in Indira Gandhi versus Raj Narayan case in 1975. Now, judicial activism refers to the proactive role played by judiciary in the protection of the rights of citizens and in promotion of justice in society. It pushes other organs of the states to discharge their constitutional duties diligently. The term judicial activism was coined by historian Arthur Schleizner Jr. in 1947. In India, it implies the authority of Supreme Court and High Court to go beyond their functional domain, even if it interferes in the matters of executive and legislature. Example, Supreme Court intervened to reform BCCI in India. Now, NET case, Supreme Court in 2016 ruled that NEET would be the only test for admission to medical courses in India. Now, judicial overreach. Judicial overreach is an undesirable situation when judicial review and judicial activism results in spur of power of executive and legislature. It is not desirable since it has the potential to destabilize the separation of power. Example, Supreme Court in Shyam Narayan Choksi versus Union of India case 2016 declared to play national anthem in cinema halls. Judicial restraint. It is the opposite of judicial activism. It requires judges to maintain status quo and limit the exercise of their powers to ensure that they do not encroach on the powers of other two branches of the government. Court of record is a court where judgments, proceedings, and acts of the court are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any subordinate court. They are recognized as legal precedents and legal references. Both Supreme Court and High Court are courts of record in India. Article 129 makes the Supreme Court court of record, which also grants it power to punish for contempt of court, and Article 215 in context of High Court. Now, contempt of court is the offense of being disobedient or being disrespectful towards a court of law. Any action which defines a court's authority or impedes the ability of the court to perform its function or willfully fails to obey a court order. As per Contempt of Court Act 1971, contempt of court is of two types: civil and criminal contempt. Now, constitutional and legal provisions for contempt of court. Article 129, that is, the Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for the contempt, not only for itself, but also of high courts, subordinate courts, and tribunals functioning in the entire country. Now, Article 142, Clause 2 enables Supreme Court to investigate and punish any person for its contempt. Article 215, every High Court shall be a court of record and shall have all the powers of such a court, including the power to punish for the contempt of itself. High courts have been given special power to punish people for this contempt of subordinate court as per Section 10 of Contempt of Court of the Contempt of Courts Act 1971. Now, types of contempt of court. Civil contempt. It is said to be committed when someone willfully breaches an undertaking given to the court or someone willfully disobeys a court order. Now, the punishment according to Section 12 of Contempt of Court Acts 1971 is punishment simple imprisonment for a term which may extend to 6 months with a fine which may extend up to 2000 rupees or which both. Now, criminal contempt, it consists mainly of three forms: words, written or spoken, actions and signs that scandalize or tend to scandalize or tend to lower the authority of any court, interferes or prejudices with any judicial proceedings, obstructs or interferes with administration of justice. Now, punishment for criminal contempt, there is no such thing prescribed in the statute. However, it is left to the court's discretion to award punishment. Limitations for criminal contempt: 1 year from the date of commission of the offense. Now, split verdict. Split verdict is passed when the bench cannot decide one way or the other in a case, either by a unanimous decision or by a majority verdict. Split verdicts can only happen when the bench has even numbers of judges. After a split verdict, the case is heard by a larger bench afresh. Supreme Court split verdicts on hijab ban. Example. Okay. Now, constitutional bench. The term bench has not been mentioned in the Constitution of India. Rather, it says that the judges would sit. There it is. So, as per Article 145, Clause 3, it is a bench of the Supreme Court of India which consists of at least 5 judges of the court which sit. So, the word sit is mentioned in the Constitution. To decide any case involving a substantial question of law as to the interpretation of the Constitution in India for purposes of hearing any references made by the President under Article 143. So 145 has clause 3 has reference to 143 as well, which is the power of President to refer cases to the Supreme Court. Now, the CGI has the power to constitute a constitutional bench and refer cases to it. Thus, presently, constitutional benches are set up on ad hoc basis, that is, whenever need arises. There is no permanent constitutional court as such in India right now. That'll be it. We'll be covering the rest of the keywords in the next subsequent videos. See you then.